Good morning. Welcome to today's webinar. GDPR is coming. Are you ready? A roadmap for controllers. Sponsored by Scott and Scott LLP, an intellectual property and technology law firm located in Southlake, Texas, recently recognized by Finance Monthly magazine as the best technology law firm in the USA. Your presenter today is Rob Scott, managing partner of Scott and Scott. He has a practice area devoted to data security and privacy. He has been helping clients who have international business interests prepare for the May 25th effective date of GDPR. Today's presentation will be recorded, and you will receive a link in the next few days to access the recording. Please enter any questions in the question box, and Rob will answer as time allows. For those of you wishing Illinois, CA, or Texas CLE credit, Diana Peterson will follow up with you after the webinar. Tomorrow, you'll receive a short survey requesting feedback on today's webinar and your ideas for future topics. We'd appreciate hearing from you. And Rob is now ready for the presentation.
Thank you, Marcus. Good morning, everybody, and thank you for attending today's presentation on GDPR. We've got a packed agenda and a very timely topic given the effective date of GDPR coming this week. I'm sure many of you have already begun preparations for compliance initiatives and have engaged in a number of healthy debates about the impact and effect of this law. And during the course of this presentation, I plan to share with you some of the basic issues that this law presents primarily to U.S. companies and their subcontractors who are processing data on their behalf. And I'll also talk to you about things that I'm encountering in my practice and some of the solutions that we've been developing for GDPR compliance for both controllers and processors within our client base. And hopefully you'll get some key takeaways today for what you need to do with your initiatives. So one of the things that is important to understand is that we've had European Union regulations in place affecting U.S. companies, and that GDPR it adds some new wrinkles, but is not completely coming out of left field. There are some aspects of this law that are new and some things that aren't so new, and there's some interesting issues to deal with. I think that the first thing that I like to tell people about GDPR is that it proceeds from a fundamentally different a political or philosophical position about privacy rights. In the United States, we have privacy on the basis of notice and choice. And in the EU, what we're seeing is that individual privacy rights are considered to be fundamental rights, just in the same way that, you know, in the US, we look at certain, the Bill of Rights as creating certain fundamental rights for us, and the right to privacy certainly has not been one of those enumerated fundamental sort of Bill of Rights type rights that we see in the United States. But in Europe, I think the importance of privacy, the fundamental nature of privacy, and in particular, abuse of privacy by large and frequently U.S.-based companies is at the heart of this legislation. This is a legislation that is primarily geared at the use of and processing of EU data by organizations in part in the EU, but the extraterritorial reach of this legislation is primarily targeted at large cloud and large social media companies in the United States. The applicability we'll talk about. We'll go into what new rights there are. We'll talk about enforcement. We'll talk about a data breach rule that is very clear. And then we'll go into how to decide how this law impacts your business and some key sort of decision tree roadmaps that we've developed for our clients. And then finally, we'll talk about preparation for compliance. Jumping right in to what's new here. We've got a broader scope. The definitions, for example, of personal data are much broader than what we've conceived of in the United States, which is primarily Privacy law in the United States is driven by what we generally refer to as personally identifiable information. It's been primarily an issue of state law. And then on the federal side, we've seen federal intervention in the area of healthcare records or health information. And then we've seen federal intervention in the area of financial data under GLBA. But I will tell you that the definition of personal data and what constitutes regulated data under GDPR is the broadest type of language that I've ever seen in any privacy regulation. And so once you start talking about what is the data that's regulated and you start to see how broad this definition is, you can start to understand why this regulation, which hasn't even gone into effect yet, is causing a huge ripple effect around the world, and particularly in the United States. We'll talk about the requirement for those companies that for whom processing is a core activity, the requirement to name a data protection officer and what the role of the data protection officer is, and whether or not you need one. We could talk about that. We'll talk about risk assessment, which is really not a new concept to privacy regulation. If you think about HIPAA, if you think about GLBA in the United States, which I think are probably the closest equivalents to this regulation, what you'll find is that ongoing risk assessment around data privacy and data security are very similar between GDPR and HIPAA and GLBA. All three require an ongoing risk assessment. They require a lot of diligence around securing and hiring outsourcers who are going to be involved in personal data. And so there's some similarities between the risk assessment obligations in GDPR and what we've seen before. Data breach notification rules, very clear cut, very quick time frames, and very clear, what the requirements are around data breach. Data transfer, data portability, we'll talk about that. Some new ideas about privacy by design and privacy by default. The concept of default is something that we know in the United States. For example, if you set the default that everybody who gets a driver's license in a particular state is going to be automatically opted in to be a organ donor, you're going to get a lot more people than if you require an opt-out to be an organ donor or a specific selection. And default is sort of how you set the parameters. And what GDPR requires is that when you're setting your defaults around data collection within your organization, that you set them to be the least intrusive, to gather the least amount of data, to make sure that your data collection and your defaults around what you collect and how you use data are set to the minimum amount necessary to do business and nothing further, and so that your defaults are set in a way to protect privacy. And then there's greater penalties. They talk about up to 4% of your annual turnover. Turnover is a European word that we would call gross revenue in the United States. So for large organizations, the penalties are quite stiff. I've been telling my clients, some of whom have been panicking this week, that for most U.S. companies, there is a very low probability that suddenly next week you're going to be facing some sort of a regulatory action. The probability is that there will be a relatively small number of U.S. companies that are held into court in Europe under GDPR in the near term, but the probability is that number will be increasing over time, primarily because there's a private right of action that we'll go into a little later that has me quite concerned from a risk management perspective, and we'll talk about that a little later. But what is the purpose? The processing of personal data is a fundamental right which needs protection. And this is, back to that philosophical point. I mean, in the United States, we wouldn't say that, that having someone process your personal data is a fundamental right. We do have laws, including common law rules in the United States, that say that a business that is entrusted to with confidential information from customers has a duty to safeguard that confidential information, similar to the premises liability law, where people who own property have a duty to make that property reasonably safe for invitees. Privacy law in the United States has been similar to, has evolved, I think, in part from those property law notions around adequate security. And so we do believe in a duty in the United States for companies to protect their customers' information, but I don't think we would ever say in the United States that it's a fundamental right, which I think once you make that statement, then you can see why this law is so broad and so intrusive from a regulatory perspective, because it emanates from that principle, which I think is different than what we would see in the United States. And it imposes specific obligations on processors and controllers, others with regard to relationships and protection of personal data. And just quickly, a processor is someone who processes data on behalf of a controller. A controller is somebody who has the customer relationship and controls that. So one way to think about it is controllers own the customer relationship and processors are vendors of the controller, would be the typical scenario. And your processors, if you're a controller, are all the vendors that you use, whether it's cloud service providers, IT service providers, back office service providers, anybody who's going to have access to personal data, those companies are your processors. And so it becomes very difficult as a controller to manage that activity. But one of the things that is required is if you're a controller and you have any EU data, you are required to enter into data processing agreements with your processors that meet certain requirements. And this is something that if you haven't begun doing, you need to start doing right away, because this is a relatively easy compliance check for a regulator to come in and say, okay, who do you use for CRM? Who do you use for accounting applications? What software do you have in the cloud? Who are your IT consultants? Who are your data center partners? All of these questions, could easily lead to a determination of non-compliance if you don't have the appropriate data processing agreement. So you're starting to see a lot of activity in the marketplace among my clients, both controllers and processors, scrambling to get their data processing agreements in place. And I'll talk to you about the strategies that I've been using for data processing agreements in a world where you have very little time and where you don't really know whether or not and to what extent a particular vendor may be processing data for you. And as a processor, you may not know which of your clients are controllers of EU data. So you're in a world where you've got regulatory obligations where you don't know the underlying facts about whether or not the regulation affects you or to what extent it affects you. And that's, I think, what we're seeing. A lot of the frenzy in the marketplace is about, we don't know what all European data we're dealing with, and therefore we've got to come up with solutions that put us in compliance quickly, but aren't necessarily dependent on reaching an agreement about whether or not and to what extent the regulation applies. And that's a big challenge, and we'll talk about that. The other purpose is requiring due diligence on processors and to have contracts containing specific provisions relating to data protection. And again, this idea of due diligence is not new, but certainly arises in a much broader way under GDPR. This slide deck, I want you guys to know, will be made available to you, and we've purposely tried to annotate in the parentheticals throughout the slide deck the articles of the GDPR that we're referring to, so that if I move quickly through some of these slides, you'll be able to use these as a resource to do further digging on a particular subject if you need to. One of the things that's new here is free movement of personal data within the EU shall be neither restricted nor prohibited for reasons connected with protection of natural persons. This is, I think, a benefit. You know, we used to have contracts for global companies where we were required to specify the jurisdictional areas where data could be stored because we were concerned about data transfer restrictions within the EU, and this legislation now makes that a little bit easier. So this is a bit of deregulation in Article 1, Sub 3. You know, one of the things that I get a lot of U.S. companies asking me about is, how is it that this law in Europe can come out and cause me to spend so much money on compliance and different things when I'm not even in Europe? Why do they even have jurisdiction over me? Why does this law even affect me? And you may be encountering some of that pushback within your own organization. And I think the one of the things that's interesting is that even in the United States, the law that controls privacy rules, unless preempted by federal law, is where the state of residence is of the person affected. And so similarly under GDPR, the argument would be made if you're a U.S. company doing business or monitoring behavior of EU subjects in the EU, then, or you're offering goods and services to EU citizens via the internet, for example, then this statute applies to you. Doesn't matter whether you're physically present in the EU or not, whether you have a business in the EU or not. Now, when I say it doesn't matter, it may affect which regulations you have to comply with. But as far as the scope of this law and who it covers, this law covers any company anywhere that is involved in processing or controlling or monitoring EU data. So very, very broad scope. A lot of new rights in this regulation. The one that I'm most concerned about and that my clients have been giving me the most feedback that they're concerned about, sorry about that, I just lost my my mouse, so I got to get back to the right slide. Here we go, is the right to be forgotten. And the right to be forgotten is, emanates from this concept that privacy is fundamental and essentially gives the data subject the right to give notice to a controller that any identifiable or personal data that is being housed within the controller's environment is to be deleted. It's a means to withdraw consent to have your personal data used. And think about broadly distributed IT infrastructures for global companies with multiple backups and redundant systems. The truth of the matter is that, particularly in the United States, we have not built our IT systems in such a way that they would be amenable to affording a particular individual the right to be forgotten. And so in many ways, I think that GDPR is going to require us to rethink the way we organize and store our data within our IT systems. And it's going to be a significant technical challenge for large companies to be able to comply with the new rights created, and in particular, the right to be forgotten. So a similar right is the right to the restriction of processing, which is essentially a way to opt out of any data processing. So there is, an enforcement scheme that is developed, and each of the member states have some independent authority, and there is a broader European board with supervisory role. And there are some certifications that are out in the marketplace. I've had a lot of clients asking me about my recommendations on certifications in connection with GDPR. And in certain circumstances, I think a GDPR certification is a means to prove compliance. And in an enforcement activity, the burden of proving compliance with the regulations is on the controller or the processor in question. So it's not about just setting up compliance programs. It's also thinking through how are we documenting and how will we prove compliance. And for certain clients, certification will be an excellent way to prove compliance. The part that everybody's worried about is revenue-based fines. 2% of worldwide turnover under Article 383, sub 4, and up to 20 million euros or 4% of organizations' worldwide turnover. This is global revenue, global gross annual revenue, which is worldwide turnover, under Article 83.5. So these are pretty stiff penalties. I think way more significant in terms of teeth, in terms of available fines than what we've seen in any other privacy regulations to date. And it's got people all over the world standing up and taking notice. The thing that I'm more worried about is this private right of action. So in the United States, for example, we have pretty extensive privacy regulation, state breach notification laws, state anti-identity theft laws, state anti-dumpster diving laws, federal privacy and security laws that regulate healthcare and financial services. But in most cases, there is no private right of action. You know, you breach a state breach notification law, and typically the only entity that has the right of action against a violator is the Attorney General of that state. And so this private right of action, which extends against data processors for any breach of the applicable sections of GDPR, with a burden of proof that lies with the data controller or the processor. So I'm putting on my plaintiff lawyer's hat and thinking we've got a very complicated regulatory regime that's going to be difficult for people to comply with. And I've got a private right of action where the burden of proof is on the defendant. You know, I don't know how creative the plaintiff's bar is in Europe, but in the United States, this looks like a field day for plaintiff's lawyers. And I'm expecting a lot of actions, private actions by EU citizens against US-based companies in Europe. And for that reason, I am counseling many of my clients to do a review of their risk management policies around cyber liability and regulatory response to ensure that any claims that arise under GDPR will not be excluded under their current policies. And there could be a number of reasons why they would be excluded. One could be the fact that your insurance could only cover actions brought in the United States. My opinion is that the vast majority of actions under GDPR will be brought not in the United States. And to the extent that they're brought against U.S. businesses, they will be brought in Europe. And so if you've got an insurance policy that covers regulatory action or privacy causes of action, private rights of action, we want to make sure that your risk management strategy is GDPR ready. And we've been spending a lot of time with our clients because I'm very concerned about this private right of action. In fact, I think you're much more likely to be the subject of one of these private rights of action than you are to be a target of a supervisory authority regulatory action where they're going after your, looking to fine you. There will be some of that, but I think that the great majority of the legal risk that's in front of us is related to private cases. So what is a data breach? A breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of, or access to personal data transmitted, stored, or otherwise processed. in the spirit of, wildly broad definitions, this one certainly fits the bill. This is, a data breach in the United States is the compromise of a system that leads to the disclosure or access to personally identifiable information where there's a probability of identity theft. That would be probably the most typical kind of definition of a breach in the United States. For example, in the United States, a loss of data, a hard drive, it blows up, or data it has destruction, for, whatever reason. That's not a privacy case in the U.S. I mean, you've got you may have a security issue, you may have a lawsuit, but that's not a privacy issue, because in the United States, we're talking about primarily the unauthorized disclosure or access. So very broad definition of data breach, much different than what we traditionally have considered to be data breaches. So when you're looking at a data breach now, you've got to not only ask yourself, all of the questions around U.S., state, and federal law, but now we've got to be asking ourselves, can we rule out the potential that there was any EU personal data involved? And if there is, you may have a situation where you've got a data breach under GDPR, but no data breach under U.S. law because of the wildly different definitions, particularly, accidental or unlawful destruction, loss, or alteration is a much broader definition than what we've seen in the U.S. So I wanted to alert you to that. If you're dealing with a data breach and you have any potential that it's got EU data in the mix of data that was lost or went missing, you need to be aware of not only the broader definition, but the extremely short time period for notification to the supervisory authority. And then if it's not made within 72 hours, must provide a reasoned justification for the delay. So if you don't get your notice in 72 hours, you're already kind of behind the 8 ball with having to explain why you delayed. What would be a good reason? I was working with law enforcement, would be a good reason. Law enforcement asked me not to make a notice right away because they were concerned it could interfere with an investigation. That would be a good reasoned justification. Your security firm was completing the remediations and told you that giving notice before the remediation was resolved would put your customers at greater risk. I think that would be a reasoned justification. So it's these types of issues that the regulation wants you to put forth if you can't make the 72 hours. So a lot of businesses right now are just trying to figure out whether I have to be compliant with GDPR. And what I've been telling my clients is GDPR is one of these deals where you're either all in or all out. You've got to make a threshold decision at the jump. Am I going to be compliant with GDPR, or am I going to try to not do anything with EU data ever? It's an either or. So for my businesses for my clients that are in the service businesses, what I've been telling them is get ahead of this, use this as an opportunity to distinguish yourself from competition, make sure that you're up on this, that you can help clients understand it. And if you're in an IT services business, then this is going to allow you to be competitive as we move forward in this increasingly global marketplace. On the other hand, if you are a brick and mortar local business with very little, you don't offer goods and services to the EU, for some of those clients, they may have a website that has tracking or cookies on it, and I may tell them, let's go all out on GDPR and let's make adjustments to our marketing and other activities so that it's clear that we're not monitoring EU behavior via our website. So, the first question is, if you're in the EU, you're covered. Are you offering goods and services in the EU, regardless of whether payment is required? You have to answer that. If you're offering any, you're in. It's not like I do a few sales in Europe, but I'm primarily in the U.S. If you offer any goods or services in the EU, you are subject to GDPR and you have to be compliant. Are you monitoring the behavior of EU data subjects as far as their data takes place in the EU? Back to the website. Yeah, I've got a client in the real estate business. They only do real estate in the U.S. They have no operations in Europe, but they've got websites that market all of their properties, and all those websites are available to EU data subjects, and frequently EU data subjects will find properties on their website and rent those properties, and they'll come to the U.S. and rent those properties, and they may be EU citizens in the U.S. renting properties. And so the question is, am I subject to GDPR or not? Well, if your website uses cookies, if your website is plugged into Google Analytics, if you use a chat function on your website that shows you anything about the user, their IP address, their country of origin, etc., all that is considered monitoring. So many companies, even those that aren't located in the EU and those that aren't offering goods or services in the EU, are monitoring the behavior of EU data subjects, even though they don't know they are, merely by having public websites that are accessible to EU citizens. So we talked about how broad the definition is of a data breach, and the definition of personal data is so broad that it's difficult to think of what kind of data a company could be collecting about a person that wouldn't fit this definition. One who can be identified directly or indirectly, in particular by reference to an identifier such as a name. I mean, in the United States, your name going missing is not a data breach. An identification number. In the U.S., certain identification numbers are considered personal data. A driver's license number, for example, could be considered personal data under certain states. A social security number, obviously, could be considered personal data. But any identification number, any location data, any online identifier, this could be screen names, this could be usernames for software applications, or factors specific to the physical, physiological, genetic, mental, economic, cultural, or social identity of that person. So this is all language, geared at social media sites, marketing and consumer analytics sites. This is anti-big data regulation right here, and to me, an inconceivably broad set of regulated data. And so with this really broad definition of personal data and a very broad definition of what kind of activity subjects you to the regulation, you could see how it's very difficult to figure out a way that this regulation doesn't apply to you. So what is processing? Under U.S. law, we have a concept of a business associate under HIPAA. A business associate would be a service provider with permitted access to health information. In GLBA, we have what's called a service provider. That would be someone who has access to financial information of a financial institution. In GDPR parlance, we have a processor. A processor is someone who processes data on behalf of a controller, and a processing has a very broad definition. Any operation or set of operations which, if performed on personal data or on sets of personal data, whether or not by automated means such as collection, recording, organization, structuring, storage, retrieval, consultation, use, etc. Very, very broad definition of what constitutes hosting. So many of you know my firm represents hundreds of IT services firms, and many of them are asking the question, do the services that we provide or the software that we offer, does it constitute processing? And they're struggling to look at their different customer relationships, determine whether or not a particular customer requires processing. And in the meantime, they're receiving data processing agreements from their customers that say, we want you to agree to a data processing agreement that says you are processing for us and that you'll comply with GDPR. And that's how a lot of this issue is surfacing. People are sending each other data processing agreements to comply with GDPR, and it causing a conversation to start. I have some clients that are both the controller and the processor on the same side of a conversation with a customer who, in other aspects of the business, is a controller and processor for them. And so one sends them a data processing agreement that's different from the data processing agreement that they want them to sign. And so it's like a negotiation. I'll sign yours if you sign mine. I've taken a slightly different approach to this, which is make an agreement if you're a service provider that says, if the services I provide to you constitute processing, then the terms of this data processing agreement will control. So you don't have to figure out whether or not you're processing and reach an agreement on that. Leave that open and just say that if you are processing, then the terms will control. We've created some different use cases for how to evaluate and map what your obligations are under GDPR. And this is a sample of the types of work papers and worksheets that we've been developing. You can see number of checklists, number of ways to sort of, initially triage whether or not you're subject to GDPR. And we are also offering consultations to clients to talk through over a initial call whether and to what extent we think, based on what they tell us on the call, they fit into any of these particular categories, and if they do, to what extent they need to take action to come into compliance. So the controller, again, determines the purpose and means of processing of data. Think of this as you're a controller to the extent that you are involved with EU data with your customers. So if your customers are in the EU or you're monitoring behavior of EU subjects, then you're a controller. A processor processes personal data on behalf of a controller. If you're a service provider, if you're a software company, if you're a consultant, if you're a storage company, if you're doing any of the things that have been broadly defined as processor, and your customers are controllers, meaning they have EU customers or are monitoring EU data on systems that you manage, or if they're putting EU data in your applications, then you will meet the definition of a processor and will need to be compliant with the obligations set forth in the regulation. A subprocessor is a party that the processor engages so that they can engage in activities on behalf, and consent is required. So we're seeing a lot of privacy policies coming out this week where processors, application hosters, cloud vendors are sending out updated privacy policies, and one of the sections is a chart of subprocessors. So you might see a cloud company saying that our subprocessors include Amazon AWS or Azure or some other third-party infrastructure provider that they've partnered with to host their infrastructure around their cloud-based application. So these are the relationship types under GDPR. It's important for you to understand which parts of your business and which activities you engage in that put you in each of these categories. And it's not uncommon for a large business to have aspects of their business where they're doing all of these things. It could be the case that in some ways you're a controller, in other ways you're a processor, in other situations you would be a sub-processor. So understanding sort of roles that you have with customers and clients is a critical first step to understanding what you need to do from a compliance perspective. There are some really straightforward things that you need to do. I mean, one of the things I like about this statute is it very clearly in a lot of ways lays out what you need to do, whereas I felt like particularly GLBA and in some respects HIPAA to a lesser extent had a lot of vague stuff that didn't give sufficient guidance to people to implement compliance programs. It was very sort of wishy-washy on what it is that they wanted us to do. But with GDPR, there are certain things that you need to be doing, and if you haven't done these things yet, I definitely recommend you get on this, immediately. And these are the things that if you were to call me and say, Rob, I think I'm covered, or I'm not sure if I'm covered and I want to get started, this is the sort of things I would start off with right away. I would want to look at, okay, where are you with contracting? If you're a controller, do we have all of your processors under an appropriate GDPR agreement? If you're processing data for your customers, then I want to make sure that we've got the right data processing piece in place. Whether you're a controller or a processor, we're going to want to take a quick look at your security policy, your privacy policies. We're going to require some new consents. You're going to need your customers to actually consent to things. And so there's a number of things that we need to do from a policy, privacy, security policy perspective, and a lot of customer-facing communications that need to take place in regards to GDPR. And if you're like me, your mailbox is full of emails from Yahoo, from all of the companies for whom there is a GDPR requirement. You're starting to see these policies, and we're actually working on a collection of all of the different policies that we're receiving. And if you have received policies that you think are interesting and you'd like to be included in the project that we're working on, feel free to email them to me. My colleague Stephen Pinson and I are working on an article where we're going to collect and compare the approaches that have been taken by the various companies that have submitted policies, and hopefully that will be a way for our clients to make better decisions about what they want to do, having the benefit of both a number of samples and our analysis of which ones we think make good sense and why we think that certain approaches may be better than others. So we talked about the DPO. If you're going to require a DPO, it's a good time to figure out, do you want to have that person on staff? Do you want to go outside to a DPO? Scott & Scott is offering DPO services for clients. If that's a service that you're interested in, we can certainly talk to you about becoming the DPO for your organization. And then NDA, confidentiality agreements, we've got to be a lot tighter around sharing of information. To the extent that it could involve EU data subjects, we want to have those NDAs and confidentiality agreements updated so that we can cover GDPR. The other thing is insurance. We talked about risk management review. Again, focusing on this private right of action and the regulatory issues associated with it. I want to make sure that you're doing a good job of focusing your risk management around and coupling it with your data privacy approaches and data mapping strategies. So what do you need to do to be in compliance for processing? Number of things here that you need to figure out. One of the things that's important that we're dealing with our clients on is the appointment of a local representative. If you don't own a business in the EU, but you are processing data in the EU, there is a requirement to designate a local representative. This is a relatively expensive thing to do. It's certainly much more expensive than getting a mail drop. This representatives have certain duties and risks associated with serving as your representative. And so the appointment of a representative is something you need to evaluate. And if it's required for you, then you need to begin looking at providers in the EU who can do that. We've made a number of recommendations to our clients for providers in the EU. If you have EU representatives that you're happy with, that you would recommend to others, please feel free to share those names with me via email, because we have a lot of clients asking about who would be a good representative to designate in the EU. We talked about certification. If you're a processor and you're interested in certification, the MSP Alliance, which is the organization that is responsible for maintaining the unified certification standard for cloud and managed services, has announced that they are going to be offering a GDPR verification certification, which I think for US-based IT firms, cloud firms, would be an excellent thing to consider. You can learn more about that at mspalliance.com. I created this little cheat sheet, 12 things that you can take from this meeting, this webinar, and go sit down and ask, where do we stand on these issues, and get a really quick sense of, where you are in the process. It just happens to be a 12-step program. There was no, I didn't borrow that from any of the treatment approaches that have been successful in substance abuse and alcohol, but I do think it's quite humorous that this is a 12-step program as well. But good little quick place to start to get a sense for where you stand. If I'm first starting to dig into GDPR, I'm going to want to focus my energy on these articles. I mean, it's a big regulation, a lot of stuff going on here. But if I'm in a U.S. company, if I'm a lawyer representing clients, or I'm in IT and I need to, get up to speed on GDPR, I'm going to read these articles first. Article 5, related to managing and access to data and protection from unauthorized access. Article 25 is privacy by design. And maybe we can have a contest one day to see who can pronounce pseudonymization the best. I know mine is somewhat suspect, and I always manage to pronounce it slightly differently each time. Article 32 on technical measures, including encryption. I've always, as a privacy lawyer, told my clients that encryption is like a get-out-of-jail-free card for privacy. And Article 32 talks about the role of encryption and its importance in connection with data protection. Article 34 is the breach notification rule. And again, unless encryption was in place at the time of the breach, once again, similar to the way we've approached it in the United States, where data is encrypted, that data is not considered to be breached, and therefore a breach notification obligation does not arise in connection with encrypted data. A very important thing to look at. Be prepared. GDPR enforcement will begin May 25th, or could begin that quickly. That's the effective date. GDPR requires significant changes for organizations who monitor or process EU citizens. On that monitoring, let's make sure that we're looking at web. Even if you're a local brick and mortar business, you really need to look at your website and make sure that either we turn off access to EU customers or EU data subjects, or if you want to let EU people look at your site, you need to make sure that there's a way that cookies and other tracking data is not being utilized. I don't think it would be worth it for a U.S. business to be subject to GDPR regulations just so EU subjects can look at their website if they're not really offering goods or services in the EU. So that's one trap here on monitoring that I want to bring to everybody's attention. Time is short. If you haven't gotten started already, it's not too late. But there's a lot of misinformation out there. In a lot of ways, GDPR has become the new Y2K or the new Sarbanes-Oxley, a buzzword affecting IT, and suddenly all applications are GDPR solutions. So I want you to be both cautious about the potential impact and what I think will be a wide sweeping impact of this regulation in the United States, but also be leery of those in the marketplace who are going to try to offer you solutions, goods and services that they present as GDPR solutions, but in effect, may just be a repackaging of old solutions for marketing purposes. With that, I'd like to open the floor up for some questions. If you have asked some questions and I don't have an opportunity to get to all of them, I will endeavor to answer as many as I can via email, with the understanding that clients of the firm, of which there are many on the call, will be given a priority. And if we can get to all of the questions, we certainly will. And if we're unable to get to your question, I certainly apologize. But for clients of the firm, you should expect an answer to all of the questions that you ask. And if you don't feel comfortable asking a question via the app, then feel free to send me an email. The first question is an easy one, which is, are the slides available? The answer to that question is yes, and they will be emailed with the survey that will come out tomorrow, and you'll have not only the slides, but a copy of the recording. So next question is the key whether goods or services are being offered or whether there is monitoring? The answer is both. If goods and services are being offered, then you're subject to the regulation. If no goods or services are being offered and you're monitoring EU data subjects, then you're subject to the regulation. So next question is about jurisdiction. And this is one that I've heard asked several times, which is, if I'm a U.S. company and I'm doing business only in the U.S. and I have no EU presence, but I'm processing data of EU data subjects, would a U.S. court recognize the jurisdiction of an EU regulator over a company operating solely on this basis? If so, what would the basis for this GDPR be in the absence of an agreement like Privacy Shield or a treaty? Thank you. Excellent question. The true answer to this is I don't know yet. But I think that the regs have done a couple of things to circumvent this, and the local representative designation is certainly one of them. If you're a U.S. company and you designate a local representative in the EU, I think you're going to be hard-pressed to argue that there's no jurisdiction over your business in the EU. This is a separate question about whether or not a U.S. court would recognize the jurisdiction of an EU regulator over a company operating in the U.S. I think largely the answer to that question is no. I don't think, for example, that there will be any cases brought in the United States by an EU regulator attempting to bring a claim under GDPR. I don't think a claim under GDPR is cognizable in the United States. It certainly wouldn't in federal court create a federal question. there would be no state or common law issues implicated purely in a GDPR claim. And so I think this question is really asking, if they take me to court and I don't respond in court in the EU and they get a judgment against me in the EU, would there be a basis for them to bring that judgment to the United States and register it in the United States and enforce it against me? And I think the answer to that is maybe. In certain circumstances, there could be a treaty or some other cooperative basis for the registration of a foreign judgment in a jurisdiction where the U.S. courts have reciprocity, such that if a U.S. company was hailed into court in Europe on a GDPR-related claim, didn't defend it, wound up with a judgment against it, could that regulator in some instances bring that to the U.S. and register it and pursue it here? I think the answer to that is maybe. And I think that's how this fact pattern would evolve, more so than whether or not anyone in the EU would bring a GDPR lawsuit in a U.S. court. I don't think that would work at all. So next question. Can you confirm that the privacy notice must be provided in the language of the country where the incident occurs? The answer is yes. There are a number of translation services that are repackaging their offerings as GDPR services for this very reason, because there's going to be quite a bit of translation that needs to be done around notices and so forth. And yes, there is a requirement that your notices be not only in plain and understandable terms, but in the language of the jurisdiction where you're sending it. Next question: would a U.S. court recognize the jurisdiction of an EU regulator? That's a duplicative question, the one we already answered. So we got that one. Would a U.S. court recognize a private right of action arising under GDPR? I think the answer is no. But that same claim theoretically could be packaged as a state case or a federal case, depending on the facts. But no, I don't envision any GDPR-related lawsuits where the cause of action is violation of GDPR being brought in the U.S. Next question. Is it the case that if a U.S. company monitors the behavior of EU citizens that live in the U.S., that the company is subject to the GDPR, even if the U.S. company has no EU operations or targeted services? The answer is yes. To the extent that you do business with EU citizens in the U.S., GDPR applies. Next question: breach notification, on the 72 hours, does the clock start from when the breach occurred, or when you got notice of it, it starts from when the breach occurred? So if you didn't get, learn of it quickly, which certainly is understandable, and I've seen that many times in various incidents, that would be a scenario where you would need to give a reason justification. Your reason justification was this was a breach that we didn't know about, and we came across it, and explaining the circumstances of that you were diligent in trying to learn about it, and once you learned about it, you did it. That's all the time we have for questions. There are a number of other questions. If you have a question and you'd like to submit it, please feel free to do so. We will endeavor to answer as many of the questions as we can via email, offline. And thank you very much for joining the presentation.